Welcome to Looking at Legal Stuff. Today we have 4 hearings with a couple who are starting divorce proceedings. She has moved her freeloading new baby daddy into the marital home and demands that her ex allow her to stay in the home and continue to pay all expenses, as he promised she could be a stay-at-home mom. Dad wants no part of that and has filed a motion to be able to move back into the home he's paying for. But that's just the start of the outrageous demands. Let's see what the judge thinks.
12 on my docket. This is 233-0045108. Ms. Petrie present representing her client Joel Lowe. Do I have Amber Lowe present?
Yes, Your Honor.
Okay. And Ms. Powers, I see you there on the behalf of the state.
That's correct. Yes.
Okay. All right. Ms. Petrie, go ahead.
Thank you, Your Honor. This is our motion, and we are asking that for a number of items. We are asking that the court adopt our parenting plan, although we would like to modify that request with regard to the residential schedule. The parties since August have been doing a 50-50 week on, week off schedule, exchanging on Sundays at 5 p.m. And that seems to be working, and the children seem to be doing well under that schedule. So my client is asking that the court adopt that schedule as part of the parenting plan versus what the local rule schedule was that we put in there initially.
Ms. Lowe, are you in agreement with that change to the visitation schedule? Are you objecting to the proposal made?
Yes, Your Honor, I agree. That's the schedule that we've been maintaining since we agreed upon separation. And it seems to be the healthiest for the children and working out the best. So I agree with the petitioner's amendment to not go with their original parenting plan, but follow with the week on, week off that we've been doing since separation.
Okay. So, and I'm just going to make sure, and again, I know I'm kind of pinch hitting here, so I want to make sure right now we're still on motions for temporary orders, correct?
Yes, this is the first hearing on this case, Your Honor.
Oh, okay.
So we are also asking that my client wants to return to the family home, and I can get into that argument in a minute. We addressed in the motion our request regarding temporary use and possession of the vehicles and property in their current possession, payment of bills. I think that was it, and child support. She in her responsive pleadings requested spousal support, although she did not make a specific request as to an amount. Your Honor, as to the marital home, my client did not agree to moving out despite mom's assertions that he did. The text messages do not reflect that he was in agreement with this option, and in fact, he never agreed to any of it. She demanded he moved out. She barked orders. She told him exactly how it was going to be, and that's what he was stuck with, or at least he felt that he was stuck with. He has a separate property interest in the home from an inheritance that was constituted the down payment. And Your Honor, the fact is, it's my client who can afford the home. She can't afford to stay in the home on her own. She's not working, and that is by choice. And she has since moved her boyfriend in. This person that she claimed in her responsive declaration was only a friend, and whom now she is 5 months pregnant by. So her representation to the court that this individual was just a support friend and just a good friend, no, it wasn't, which validates my client's accounting of the facts in this case. The situation mom is currently in is of her own doing because of her choices. That does not relieve her of the responsibility now to support herself and to equally support her children. She expects my client to support her boyfriend, and their new child. And so where is her boyfriend's obligation? That's what we have to ask. Why should my client be paying for a house for him to live in rent free? He's not paying rent. And my client is not only the out spouse, but the expectations that she places on him in the text messages are untenable and unfair. She demands money. She demands gas in her car. She demands groceries. She demands diapers. He doesn't mind those things, but he is also paying for her housing. He's paying the utilities. And in fact, he believes that her boyfriend is working out of the marital home using the internet he's paying for. So my client is continuing to pay for the internet and the utilities to make sure that they're paid, and so his credit doesn't get affected, and to make sure his children are safe. But he is seriously being taken advantage of here. That being said, there is absolutely no reason she cannot be working. And as the court is aware, we just agreed to a 50-50 residential schedule. So that means that there's no reason she can't be working on her off weeks from the children. I'd like to point out for the court that she did not file a proposed parenting plan. She did not file a financial declaration. We have no idea what her expenses are, what her income is, if she has any. She needs to get a job. If her boyfriend isn't working, he needs to be. If he isn't working, then he needs to, if he is working, then he needs to pay rent, thereby reducing my client's obligation. He can choose to pay rent to my client, or he can find his own place. My client is paying for everything right now and has been since this whole thing occurred, where she just picked up and left with no notice for a month and 3 weeks, and then just expects him to be out of the house, expects it to be in perfect shape, perfect condition upon her return. My client wanted me to address the flea situation and the messiness of the house. The house is not as messy as she tries to represent. And here this guy is trying to take care of these kids and take care of kittens that she initially brought in. She decided to foster a bunch of flea-ridden kittens, and she brought them in the house. The flea issue started because of her. And then she tried to blame it on him, and now she's trying to use this declaration in this court process to say that it's him, it's his fault, it's his neglect, which is not the case. She also made some serious allegations about sexual assault, and then talked to my client subsequently, wherein she informed him that, well, the last time they were together, she just didn't want to. Never once did she say no. Never once did she ask him to stop. She never yelled, she never screamed, she never cried, she never called the police, she never sought a restraining order. Even now, in response to our motion, she's not even seeking any kind of protection order or restraining order against my client. She has no fear. You can't consent to something and then turn around and claim it to be an assault just because it wasn't something you wanted at the time. If you didn't want it at the time, you need to speak up. You need to fight back. She didn't. So she can't come now to the court and say that my client is an abuser and that he sexually assaulted her. Not to mention the fact that it was not in the middle of a fight. It did not occur out of rage or extreme emotions. It just occurred. They're a married couple. As to requests for her spousal support, she makes no specific requests. She provides no financial documents. We have no idea what the status is of her boyfriend. And she is simply claiming that because they were married and during the marriage, she got to be the stay-at-home mom, she should continue to live that life of luxury just after it was her decision to end the marriage, and not have to support herself or equally support the children. So we are asking that our motion be granted, Your Honor.
Right. Ms. Lowe, I have also received your response. I did not receive a proposed parenting plan from you, but I have received your response to the petitioner's proposed parenting plan. What would you like the court to know?
Well, Your Honor, there's many discrepancies in the petitioner's responses. I would just like the court to know that we had a mutual agreement when I wanted to get divorced that he would move out of the house. There was abuse in the relationship. That's why I left the home, marital home, during the time so that he could move out and it was safe. So when I returned, I have text messages showing that he knew I was at the airport. I was on my way home. He was preparing one of the vehicles for me. And originally he had said I could live in the marital home for a year. And then after I got back, everything changed. I am also 2 months pregnant, not 5 months pregnant. In regards to the sexual assault, I did cry. I did say no. I don't feel like it's necessarily appropriate for court, especially with me with no counsel, but I can't afford counsel at this time. I've done everything in my ability so far of filing TANF and filing for child support. I have thrown out many suggestions to the petitioner, such as splitting the mortgage on the marital home or him not paying the mortgage at all and me just continuing to raise the children in the marital home. I've been a stay-at-home mom since the birth of both of our children. So for those reasons, that's why I asked to stay. And that was our agreement. And he was moved out when I came back. So
And
I'm sorry, Your Honor.
And there's another adult living in the house with you at this time?
There is. I don't receive any support through the state for my other child that lives in the home who's 10 from a previous marriage, relationship, and I don't receive any kind of support for my significant other, who I am pregnant with right now.
And is your significant other who's living in the marital house with you paying any of the expenses for the home?
No, Your Honor, but I have offered to start paying expenses in the home. I've never asked the petitioner to pay the mortgage. It was his conclusion that he was going to keep doing it. He said he didn't want the power to go out on the children. But my only request was to stay in the marital home and raise my children. I'm very flexible on everything else, but because this is a first hearing, we haven't gotten that far, and I can't afford counsel at this time. So I'm just kind of
And then
doing what I'm able to.
the period of time that you left Washington was about a month and a half, is that right?
Yes, Your Honor.
And the children stayed in the home with Mr. Lowe?
Yes, Your Honor.
Okay. So what I'm going to do, going through the petitioner's proposed temporary parenting plan, give you my ruling, and then Ms. Petrie, if you would be so kind as to make any changes per my order. I'll open it up for questions too. Jump in if anyone has questions as I go through this. So number one, in general, I'll adopt the petitioner's proposed plan with some changes. After review of the record, while I do think there is some evidence of probably more like 3B problems on mother's part, I am going to reserve for now on 3A and B limiting factors. We'll reserve those for the final order. Decision making at this time, for school, educational, healthcare will be joint. I will adopt dispute resolution and custodian section 6 and 7 as written. The parenting time schedule, I will adopt with the oral agreement that the parties have made here on the record today. That will include numbers 9 and 10 for summer schedule and holiday schedule. I don't see it directly in here, but I am going to order that Mr. Lowe remain in the marital home at this time. Do not believe it's appropriate for this court to order that Mr. Lowe pay expenses of this home while a new significant other is in the home. I also don't believe, without further investigation, that it's appropriate that the children at this time be expected to reside with a significant other that the court knows nothing about. So Mr. Lowe is to return to the home. Ms. Lowe is to vacate. Mr. Lowe will be responsible for payment of the, and I believe you had that listed in your original motion, all of the expenses related to the home. Yes, which includes the mortgage, utilities, insurance, property taxes, vehicle. All of that will be the responsibility of petitioner. As I understand it, this is a 5-year marriage. I'm not ordering support at this time. Excuse me, I'm not ordering any sort of alimony or marital payments to Ms. Lowe at this time in a temporary order. I will adopt 11, 12, 13, 14 as proposed by petitioner. I'm going over to the temporary family law order that petitioner proposed. I'm just looking through to see, I believe it's mostly in accordance with exactly what I've already ruled on today. So I will adopt in its entirety then the temporary family law order, which does require that the petitioner or allow the petitioner to return to the home and stay in the family home. Respondent must move out of the family home within 30 days of today's date.
Your Honor, will the court address child support today?
I was just going to turn to you and ask the state if, based on my rulings on the temporary orders, if there were any changes to the state's proposals for child support.
There's not. The kids are receiving TANF benefits, and that I know that is a little more complicated because the statute prohibits a residential credit when the children are receiving TANF benefits. Our proposed worksheets were filed November 13th. We used the father's actual income based on his September 29th wage stub, which he filed with the court. The mother has no employment security history, so we imputed her at minimum wage 32 hours per week. I do note that that results in a transfer payment of $1,787 a month from father to essentially to the state of Washington, so long as mom remains on TANF. I do recognize, given your ruling, that may seem somewhat unequitable, but I'm not aware of an exception under the law, at least not in regards to a residential credit.
I do believe a residential credit would be appropriate, considering that they are going to be doing 50-50. And it is for 2 children. I also would request that she be imputed at 40 hours a week. There's absolutely no reason she can't work full time. My client certainly doesn't. He gets by.
And just briefly in reply, Your Honor, the statute, which I don't have in front of me right now, specifically says that a residential credit cannot be granted when a parent is receiving TANF. TANF is evidence that there's insufficient funds in the household to support the children. And then in terms of the mother's income, we followed the imputation statute, which indicates when there's no employment history and a parent is receiving TANF benefits, they're to be imputed at minimum wage 32 hours per week.
Here's what I'm going to do on this, because I don't have, I'm just looking through my papers diligently. Sometimes things get attached to the back of them.
We did not send over a proposed order. I was unsure where primary parent would land.
Understood. Let's do this because let's set this case to December 5 for presentation of the orders I've already ruled on, unless they get signed ahead of time. But it sounds like maybe if Ms. Petrie is arguing that there should be a residential credit, obviously the state's arguing the statute doesn't allow that. We'll set this on for a hearing as to child support on December 5th at 1 o'clock, along with presentation, if that has not already been signed.
Okay.
Okay.
And then certainly, Ms. Petrie, if you want to file briefing with the court, I'll give Judge Bassett a heads up that issue's coming. But if you want to file any short briefing, feel free to do so. Any questions or clarifications on the temporary orders?
Yes, Your Honor. I would just ask that since the court is granting his petition to have me move within 30 days, given my circumstances of him leaving the home willingly and my pregnancy and having to relocate my other kids, including the ones I share with him, that at this time, I be given more than 30 days to find new residents. I know the petitioner had told me in person that he would extend it till January if it went this way, but I don't know what their feelings are on the matter.
What I'm going to do right now, and one of the reasons I'm making this ruling is I do think it's wholly inappropriate that for this court to have Mr. Lowe paying for household expenses when another adult is living in that marital house. So I am going to keep the 30 days right now. But if Ms. Petrie wants to, if her client wants to work with Ms. Lowe on an extension of that, we can certainly add that to the order. I have no issue with the parties going beyond 30 days. I wouldn't agree to anything less than 30 days. I do think that 30 days to move out is sufficient. But again, if Mr. Lowe wants to agree to longer, feel free to put that in the order. I have no problem signing that.
Okay, thank you, Your Honor.
Any other questions?
No, Your Honor.
Okay, thank you all. If there's no other questions, you all are free to log out.
Low and low 2330045108. Another presentation of an order.
Actually, Your Honor, the presentation portion of this should be struck. The court signed off and the orders were filed November 28th. But we just have the remaining matter of child support pending.
All right, that's not what Odyssey says. I do see that the temporary family law order was signed off on by Judge Scudder on the 28th of November, along with what appears to be temporary parenting plan. Ms. Powers did file a memorandum of authorities regarding child support.
Commissioner Carmi set the issue of child support over to today from the November 21st hearing.
Correct.
Okay. All right, well, who wants to start?
I'll go ahead since the child is receiving TANF benefits, the children are receiving TANF benefits. We filed our proposed worksheets with the court on November 13th. The father's income is his actual income calculated from his September 29th, 2023 wage stub. And his deductions were taken from the same wage stub. The mother has no employment security data and indicated she's not working and she's a current TANF recipient. So we imputed her at minimum wage 32 hours per week. The issue is that we've got a joint parenting plan, but because the kids receive TANF, the court is unable to enter a residential credit. So all of this would result in a transfer payment from the father to the mother of $1,787 a month. TANF began at the end of August and as of today is still active.
All right, Ms. Petrie.
Thank you, Your Honor. Your Honor, we concede that the state is correct regarding the deviations in this situation where mother is receiving TANF benefits. However, in my review of RCW 261975, the court has discretion as the options stated within the code is not an exhausted list. Section 1 states reason for deviation include but are not limited to the following and goes into the criteria. And then section 4 also references the discretion of the court in considering the extent to which the factors would affect the support obligation. My only argument here, Your Honor, is that of equity. My client is named the primary parent. And as such, he is being obligated to pay support to the non-custodial parent under a 50-50 residential schedule. To not grant a deviation would result in an inequitable order of the support. Given that my client is the primary parent, I must question mom's actual qualification for TANF benefits at this point. I'm also slightly concerned because the Department of Child Support is already put in a wage assignment order without this order being entered. We did alert them to the fact that there was a child support action pending. Again, the outcome proposed by the state, though, will result in an order that is more in favor of one party to the other's detriment. My client is moving back into the marital home. He is going to be responsible for maintaining that home. Mother is cohabiting with a significant other. He is not working. So, the idea that my client should need to support him as well is not exactly an equitable outcome either. It's just unfair, Your Honor, that the primary parent, just because she's getting TANF benefits, would have to pay so much in support. So we are requesting a deviation. However, the court wants to label it. We are asking the court to exercise its discretion in awarding a deviation, so as to not overburden my client and unjustly enrich mother.
All right, thank you. Ms. Lowe, anything that you would like to add at this point?
Yes, Your Honor. I can't afford counsel at this time. I was a stay-at-home mom for the last 10 years, and that was agreed upon between me and the petitioner. I don't have a track record right now of employment. I have been looking for work every single day since I applied for TANF. I am looking for residence also. I have a month. I've been given a month after being a stay-at-home mom for 10 years to find work and a home. My partner is not living with me currently. He is my boyfriend. He is my partner, but I don't have a home right now, Your Honor. I'm in the marital home until January 1st. So I'm scrambling to try and figure out what I can do and trying everything that I can to find housing and get back on my feet. But I certainly do qualify for TANF. That's why they approved it. And I'm also exempt right now. If I didn't want to look for work, I wouldn't have to right now, technically, because I'm exempt because we have a 1-year-old who I also have to find daycare for. But I am looking for work. I've even applied for DoorDash. I'd also like to note that the petitioner never had problems in the past with paying for the mortgage and paying for our lifestyle. He makes a significant amount of money, always has, which is why we agreed that I would stay home. Also, I want the courts to know that for the last 4 months, the petitioner has been depositing $250 to $350 in my account every Thursday, and he was calling it alimony and support. And that's on top of what the state's asking for. I don't think the state is out of line in what they're asking for in child support, given his income. And they've submitted all of that. And certainly when I find work, my TANF will be adjusted and go down. But at this time right now, he is the breadwinner. He always has been. And I have to go from being at home, being a stay-at-home mom with 3 kids, to making everything work. So I don't know. I feel that it's fair, Your Honor, but I will leave it up to you to decide what you think is fit. Thank you.
Brief rebuttal, Your Honor.
Yes, go ahead, Ms. Petrie.
Your Honor, I know Ms. Lowe seems to think that she should be allowed to stay home forever. However, she has to remember that she's the one that made the decision to end this marriage and move on. And she's the one that put herself in this position due to her choices. And if the court would refer to the recording of the last hearing, and also in the declarations. There are not 3 children before the court today. There are only 2. My client is only responsible for 2 children. With regard to this case and the child support issue, I am requesting again a deviation. $1,700 is a great deal to have to pay, given the situation and my client's role as custodial parent. Thank you.
All right, thank you. So I did review the minutes from the 21st hearing, I was able to, Ms. Powers pointed out when they filed their information, I went through the proposed worksheets from the state, reviewing the income and the information provided about the deviation based on the TANF. It is a relatively shared parenting plan based on my quick review of what was entered. And I don't see anything indicating that at this point no spousal support was ordered. Is that correct?
Correct.
All right.
Correct, Your Honor.
This is simply for support for the children that are essentially a little over half time with father and almost half time with mother. So based on
Half and half equally, Your Honor.
don't interrupt me, please. So everything I've reviewed, I am gonna make a slight deviation. I'm gonna order $1,500 a month in support, child support, based on the numbers. And I guess Ms. Powers, would the state want that starting December 1 or November 1?
I think we would request November 1 because the children have been on TANF since the end of August. So.
Your Honor, there is an issue about arrears. The current Department of Child Support action there, the administrative action is going after him for back payments back to August. That shouldn't be happening, and at a minimum, he should be receiving a credit for the payments that he voluntarily paid, admitted to today herein on the record by Ms. Lowe. He should be credited back those payments for the ones he's already been made in any calculation that DCS might make.
Ms. Powers, does state have any position on that?
Well, the difficulty is that in terms of a court order, the petition, I believe the petition in this action was filed in October, so the court's earliest child support date would be November 1st. Under the WACs, the DCS has the ability administratively to go back. Before that, certainly any court order that's entered as of the day that it starts will supersede any administrative order. I guess I'm not being very helpful here.
I'm just concerned that the child support garnishment is already going into effect with my client's employer at this time when this order wasn't even made. And they're going after arrearages that should not be gone after. So some attention needs to be paid to the accounting on this case.
If wages are already being taken from an employer, it means an administrative order has been entered. If you give me a minute, I can verify that really fast.
I'm sorry to take up the court's time with this, but I just need to make sure my client isn't getting double dinged.
No, that makes sense.
It looks like there was an administrative order that was entered on November 16th, effective August 30th. The father would have had the ability to participate administratively. The administrative order will be superseded by this, although if our start date is November 1st, then the admin would still remain in effect from August 30th through October 31st.
And what did they set the amount at? What is he being garnished a month?
They set the transfer payment at $1,949 a month. And it looks like there's also a medical premium that they set of $487
a month.
Yes.
So that's about $5,000 for 2 months that he's supposedly in arrears that they entered.
No, they set current support at $1,949 a month plus $487 a month in medical.
Yeah, which is about $2,500, and that's for 2 different months.
Correct.
September and
Yes.
October.
Yes.
So almost right around $5,000 that they consider him in arrears, even though there was nothing entered by
It's
the court.
showing 5,972.74. If the court enters an order that covers the dates of August 30th on, it will supersede the whole administrative order.
Well, I don't know if I have the authority to enter an order that predates the filing of the cause.
I don't know that you do either.
The court can set arrears at this point effective. Set the arrears as 0 effective November 1st.
Would that supersede Ms. Powers? If the court set a specific amount of arrears as of November 1st or the filing date of this cause?
If the court entered a judgment that said it was for arrears that covered from August 30th on, it would supersede the administrative order. I would object to 0 since the kids did receive TANF at that time period, but that would be a way to supersede the order.
Except that my client was giving her around over $1,000 a month voluntarily. And she was receiving TANF.
Your Honor, the money that the petitioner was giving me, he said was for alimony, not for child support. And he also said he wasn't going to pay back TANF. We both got the same paperwork, me and the petitioner, and he came to me and said that he thought it was unfair.
Objection, Your Honor.
Pay it.
It's irrelevant.
And I guess I'm concerned because I was not aware until this hearing today that the father had been directly paying the mother. And it is true that when a parent's receiving TANF, any money they're receiving for support, either spousal support or child support, is supposed to be reported to the community service office because it's assigned to the state of Washington.
That is
because
correct.
of the TANF benefits.
They're not legal payments. He's been gifting them to me as a gift because of my circumstances.
That's not how that works, Ms. Lowe. So that's a concern. That's not how that works. Are Ms. Powers and Ms. Petrie and Ms. Lowe, are you, the 3 of you, available next Tuesday?
I am.
Yes.
Ms. Lowe, can you reach out to Ms. Powers and Ms. Petrie if we can find out how much, because clearly Ms. Lowe is indicating that he, however she wants to phrase it, gifts her approximately $250, $350 a month, or excuse me, a week for the last however long. That's something that clearly needs to be taken into consideration, and that's something that we can potentially set the amount of arrearages at that amount and say that it's already been paid, essentially. And I think that would be a resolution to this, but I don't want to spend more docket time trying to figure out those numbers. So
understood. I am available next Tuesday.
All right. So, Madam Clerk, if we could just pass this matter over 1 week just to determine the amount of arrearages, and then I'm happy to enter a court order reflecting that amount. So hopefully that will trump the administrative order that was entered that has the $5,900 amount on it.
Would the court like me to have an order drafted for next week?
Sure, that would be great.
That would be helpful. Thank you, Ms. Powers.
Thank you.
All right. I'd appreciate the 3 of you having some communication so we can hopefully get that sorted out next Tuesday. And that is the 12th at 1 p.m.
All right. Thank you so much, Your Honor.
Thank you.
Thank you.
I have a couple of matters that I know are going to be rather quick and a matter I need to strike. I'm going to ask if there's any other cases that are being passed today, struck today, or if there's agreed continuances and anything.
Your Honor, Amy Powers for the state of Washington. I would ask that number 13, Joel Lowe versus Amber Lowe, be set over 1 week. I just received the financial information I was waiting on yesterday and need a little more time to get an order out.
All right. Ms. Petrie, any position?
No objection, Your Honor.
All right. Ms. Lowe, any objection to the 19th at 1? You're muted. I can't hear you.
Can you hear me?
I can, yes, thank you.
Okay, thank you, Your Honor. I don't have any objection to it, but I have been looking for a new home and I have less than 30 days and everywhere has been asking me for written proof on how much I'll be receiving in child support. So I would like to try and get that done as soon as possible so that I can move on to finding a new residence for me and my kids. But I know the state didn't have time to write anything up yet because they just got the last document today, so.
Okay. And I appreciate that, Miss Lowe. I think the 19th is closed. I'm gonna allow this to be added to the 19th because I don't think it will take much time. But and I do appreciate that. So we'll set this over 1 week to the 19th at 1 p.m.
Thank you, Your
Thank
Honor.
you.
Thank you very much. All right. Any other strikes or setovers or quick matters?
This is Georgia Petrie again. I do believe that the Lowe matter, LOWE, will be a short matter.
All right. I just received some new updated orders. Let me get, this is cause number 2330045108. And Ms. Powers is here. And Amber Lowe is here. All right.
I believe that the temporary child support order incorporates what the court was wanting. Ms. Petrie, I apologize. Am I getting that wrong?
No, you're correct, Petrie.
Okay, Ms. Petrie and I had agreed that rather than do a back support judgment, the order could just start August 30th. And then section 25 of the order records the payments that the father made directly to the mother and instructs DCS to give him credit for those payments.
All right.
I am in agreement with the state's proposed orders.
And Ms. Lowe, have you received copies of those proposed orders?
I have, Your Honor.
And any questions or concerns about those?
No, Your Honor.
All right. May I indicate for both Ms. Petrie and Ms. Lowe that you approved via Zoom for the paperwork?
Yes, Your Honor.
Yes, Your Honor.
All right. I've reviewed that paperwork and hold on 1 second. I just got an email and it's Ms. Petrie, it looks like Mr. Lowe is waiting for a Zoom booth here. Both Zoom booths are occupied to join the hearing. So I don't know. I'm assuming you've been in touch with him and you're comfortable moving forward and just getting in contact with him.
Yes, he and I have already discussed the order, and I do believe that my paralegal can reach out to him. They're observing right now.
He's getting in the booth right now. My mom just stepped.
There he is.
Okay, I have gone through the worksheet and the child support order, reviewed all of that, and I have signed both of those orders.
And can I just double check? Our office had sent over 2 different temporary child support orders, so I want to make sure you signed the correct one. On page 1, under money judgment summary, it says no summary judgment is ordered.
That is the one
Perfect.
I just signed.
Perfect. All right. Thank you.
All right, and I will, I'm assuming the other one came prior. I can just recycle.
Correct.
Perfect. All right. So Low and Low are ready to go. Thank you very much.
Your Honor.
Thanks.
Thank you, Your Honor.
Thank you. All right, let's go Krebling and Hogan or Hagen, 12300706-8.
That letter's ready, Your Honor.